Hey guys, welcome back to Kitchen Court Cases, where we watch court in my kitchen. Let's see what we've got today.
Three violations as outlined in the motion with explanation and proceed to disposition at this time.
Very well. Mr. Chamberlain, I'm sure you've heard the announcement of your attorney, Mr. Paul. He's suggesting that you're waiving your right to a hearing in this case, and instead you're going to stipulate and agree that you committed the violations as alleged. Is that indeed your intention?
Yes, sir.
Okay, you're gonna need to speak up for some reason. Okay.
Yes, sir.
All right, I just need to make sure that you're aware that we're here as a result of your conviction for failure to register as an offender. You were sentenced on that on May 27, 2021 to a controlling sentence of 24 months Department of Corrections, 24 months post release supervision. This court did grant a dispositional departure in that case downward and allowed you to go on probation. Violations that are now alleged include failing to report to your ISO on 2 occasions back in the summer of 2022, failure to remain in sober living, failure to keep your ISO notified of your place of residence. At that time, apparently your whereabouts were unknown. As that has been suggested, you do have the right to a hearing, but you would have the right for the benefit of counsel to represent you, present evidence on your own behalf, challenge the state's evidence, confront their witnesses unless good cause was shown. And I need to make sure you're aware that among other lesser remedies, the court could consider just an outright revocation of your probation and have you serve the remaining balance of your sentence in Secretary of Corrections custody. Do you understand these things, Ms. Chamberlain?
Yes, I do.
And do you now stipulate and agree that you committed these violations and waive your right to a hearing?
Yes, I do.
All right. Court finds that the defendant has been made aware of her rights, that she does waive her right to a due process hearing in this case, and stipulates and agrees that she committed the violations 1, 2, and 3 in the motion to revoke probation as outlined by the court earlier. The court does find that these are substantial and material violations of the terms and conditions of her probation. The court will now turn to disposition. I'm going to address Mary Ann Shirley on behalf of the state of Kansas first for a recommendation regarding such disposition. Ms. Shirley?
Your Honor, it's my understanding that this is not the first revocation, that after the last revocation for similar violations, she had a 60-day sanction imposed. Apparently, that did not get her attention. I'm not sure if there's anything other that she's in custody otherwise than this, but at this point, it appears she has served approximately 120. She has served approximately 6 months on this case, and as of the date of the filing of revocation, that apparently had not made an impact on her. At this point, I think the state's recommendation would be that she just serve her time and close it out.
All right, very well, Ms. Shirley. Mr. Potter, your recommendations regarding an appropriate disposition?
Judge, Ms. Chamberlain would ask for one last chance on probation. One of the violations was a failure to remain in sober living. She'd gotten COVID and was kicked out of that sober living environment and was never given an opportunity to return. Ms. Chamberlain has been suffering from some homelessness. Now she's got that back. It looks like she's got that back on track. She advises me, Judge, that she has living arrangements in Augusta. She had forgotten about her court date, and Judge, she just got scared and didn't show up, and now she's here before you today. You know, she is unemployed, but she was working. She was looking for work until the bondsman turned her in on her bond. Judge, I would say that you know, even though this was originally filed in August of 2022, the motion for probation, we're having the hearing this much later in the calendar, that Ms. Chamberlain has not been charged or even suspected of any new crimes. So, Judge, for those reasons, we would ask that you give her one last chance on probation.
Very well. Do you know, Mr. Paul, why she is currently being held in the Butler County Detention Facility rather than in Greenwood?
I do. Judge, she has another warrant to show cause in front of Judge Satterfield on February 24th.
All right, understood. Thank you, Mr. Paul. Ms. Ashton Felter, do you have anything as the supervising ISO in this case to add to Ms. Shirley's presentation to the court?
I do not, Your Honor.
All right, thank you. All right, last but certainly not least, the court will address Valerie Chamberlain personally, and I'll ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she personally would like to present. Ms. Chamberlain?
Your Honor, I've been through a lot of stuff and I've tried to overcome all of it. I've tried to stay away from drugs. I've tried to do my very best. And I know that I've messed up and I've gone the wrong direction. And I hate to blame anybody else for what I've done. But I really think that I can do it.
Okay, you're kind of fading off there, Ms. Chamberlain. I want to make sure I hear everything you have to say.
I think if you just give me one more chance, I think I can do it. I don't know what to say, except that I'm sorry.
Okay. All right. Thank you. Court has previously, pursuant to the defendant's stipulation, found that the violations alleged are substantial material violations of the terms and conditions of her probation. While I certainly can accept the explanation given by Mr. Paul regarding the second violation, failure to remain in sober living, court is aware that many treatment and other facilities discharge people when they got COVID or some related disease. However, it doesn't explain why she didn't contact her officer and try to rearrange readmission into that or another similar facility. She certainly had plenty of time to do that. Court also finds that the failure to report to an ISO to be a serious violation is fundamental to her probation in the first place, and keeping the ISO notified of where she is, which is obviously an important component of probation and the supervision for that probation. I'll also note that this was a dispositional departure in the case. The legislature had basically determined that Ms. Chamberlain was supposed to go to prison at the outset of sentencing in this case and not be given an opportunity for probation. This court did grant its discretion, found substantial and compelling reasons that were argued to this court to give Ms. Chamberlain the chance at that time. And it does appear at this point that this has just simply been an unsuccessful probation in this case. The court also notes that Ms. Chamberlain did not appear for her scheduled hearing before this court on November the 2nd of 2022, where perhaps some explanation might have been given that might have had some influence on this court. But Ms. Chamberlain, in this court, you don't fail to show up for your probation revocation hearing. I think that indicates as strongly as anything that you're not going to be successful if you're not going to show up for court. Why would this court believe that from that point forward, you're going to follow rules and that you're going to do what you're supposed to do? So the court declares this, and unfortunately, an unsuccessful probation in this case. Court does outright revoke the probation of Valerie Chamberlain, has considered but rejects a lesser sentence, and imposes the remaining balance of the original 24-month prison sentence in this case. Court reannounces the 24-month post-release supervision period. Any unpaid amounts need to be referred to collections if they haven't been already. I won't be assessing any additional amounts for Mr. Paw's services for this round. I want to see if the original journal entry ran this consecutively or concurrent with anything. I don't see any reference in the journal entry to concurrent or consecutive sentences involving other cases. Perhaps Judge Satterfield's case addresses that in relation to this case.
She ordered it to be run concurrent.
I'm
Judge
sorry.
Judge Satterfield ordered it to be run concurrent.
Okay. Well, that's something to be addressed in Judge Satterfield's court. I will not make a ruling one way or the other here, as it wouldn't appear to be appropriate for this court to do so. All right, with those rulings made then, Ms. Shirley, are you aware of anything else that a particular ruling is needed from this court?
I believe that we need to determine, she apparently has got some more time. I'm not sure whether it should go to this case or to Judge Satterfield's case. How she's being held, if it's strictly on this or if it's on both of them. There may be some time credited, to this case that we would need to modify. That we
Or if
would
they're run
need-
concurrently, it may not matter. It's just, we may be looking at, or DOC will just be looking at an aggregate number of jail time days to be credited. But I don't know with certainty that
I don't
they're
either.
going to be concurrently run. So if you can, Ms. Shirley, if your office can research that in conjunction with both jail facilities and determine in the journal entry stemming from today's proceedings what an accurate number of jail time credit days. And then if you determine also that Judge Satterfield's case is run concurrently, and perhaps out of state in this journal entry, that this jail time is all credited for this case and concurrent case number, whatever Judge Satterfield's case number is. That would make it clear to the reader that all jail time credit has been contemplated.
Thank you, Your Honor.
Okay, thank you. Mr. Paul, anything further from your perspective that the court needs to address?
Judge, I know you talked about waiving my attorney's fees. Are you also waiving the application fee?
I am.
Okay, nothing further then, Judge. Thank you.
Very well, Ms. Chamberlain. I would just advise you to take advantage of any rehabilitative programs that are offered to you in the Department of Corrections. Try to earn every possible good time credit day to earn your earliest possible release date and maximize your potential to be successful in the community when you're discharged. If there's nothing further, then the court will remand the custody of Ms. Chamberlain to the appropriate jail officials until her custody can be transferred to the Department of Corrections to serve the remaining balance of the 24-month sentence imposed in this case. This matter is currently in recess, and I would ask for all of you to go ahead and leave the meeting at this time. You can stop recording and broadcast.
Well, that was interesting. She asked for one more chance. He said, no, not going to happen. Again, I imagine if she had showed up right after she got kicked out of the facility with COVID, she probably might have got given another chance. But looks like Judge David Ricke doesn't play. So I thought that was an interesting case. Failure to register as an offender. I wonder if that's an S offender, if you will. I don't know. Anyways, that was in Kansas, in the Butler County Detention Center, and Judge David Ricke. Anyways, thanks for tuning in, guys. I hope to catch you on the next case. Bye.